Next is a contribution which is made by employer towards the pension or provident fund. In the previous labor laws which we have studied in the last semester, we have already seen what is provident fund or the concept of pension. Provident fund is nothing but a kind of fund which is being created with the contribution of both employer as well as employee, and through that fund can be given to the employees in certain circumstances. And the pension at the time of retirement, there are several new pension schemes which are offered by the government as well as other different bodies. So the definition says that such contributions wherein employer is paying something on behalf of the employee or for the employee, not on behalf of the employee but for the employee, then in that case such contributions shall not be considered as a part of the wage. Because see, this provident fund says that there should be maybe 3% or 2% of the salary of the employee should be considered as a contribution which the employer has to pay towards this provident fund or accumulation of the provident fund from the employer side. There would also be a contribution from the side of the employee for the same. So this definition says that such provident funds or such pension funds or contributions which are being made by the employers for the employees, it will not be considered as a part of the term wages. Next is any conveyance allowance or value of traveling concession. So if there is any conveyance allowance or traveling concession which is being paid by the employer to the employee, right, for traveling from his home to the industry or to the place of work, then such allowances will also not be considered as a part of the wage. It should, employer should not claim that this is something which is a part of a wage and hence you have to, hence your actual wages, on-hand wages are lesser because I am giving you all these stuffs. So any conveyance allowance or value of traveling concession is not a part of the wage. Other than this, any sum which is paid to defray special expenses entailed on employees by the nature of his employment would also not be considered as a part of wages. So any special expenses, for example, if I am an employee and I have been given a task of posting some stuffs, maybe some products, and for that posting I may need to have some envelopes, I may need to courier it, I may need to stitch this the postal tickets and several other allied expenses are there. The photocopying of some material is required. So all these expenses which are entailed by virtue of the employment on the employee, it will be considered as a part of the wages. It is not something which is a wage or which is considered as a wage for any employee. It is something that has to be paid by the employer to defray the expenses that the employee is bearing. Even for example, the stationery items that the employees are requiring in during the employment. So if in case employees are paying for such stationery stuff, that is not any expenses or any sum which is paid for such stationery expenses, it should not be considered as a part of the wage. It is something which is extra or something in addition of the wage that has to be paid by the employer to the employee, because it is such expenses are entailed to defray the the expenses which are entailed by nature of the employment to the employee. Next is any house rent allowance. There are some employers who also pay house rent allowance. So such house rent allowances also do not form part of the term wages. If at all the employer is providing any house rent allowance, maybe 3%, 5% or 50% of house rent allowance, or maybe the full house rent allowance to the employees, such as HRAs, house rent allowance shall not be considered as a part of the wage by the employer or the employee. Next is any remuneration which is payable under any award or settlement. If there is any award, we have already seen the Industrial Disputes Act and the other allied labor laws, wherein there are some settlements and there are certain awards which are being adjudicated by the labor courts or tribunals, and it could be in favor of either employer or employee. So in cases when it is in favor of the employee, and if such awards or such settlements are there, the amounts toward amounts amounts no sorry amount which is being paid for to towards such settlements should not be considered as a part of the wages. Next is any overtime allowance. If in case employee is working overtime other than the regular working hours or in addition to the regular working hours, then in that case whatever overtime has to be paid, that is also not something which is a wage or which should be considered as a part of the wage. It is in addition of the wage that has to be paid by the employer, because the worker has worked overtime and because there are certain provisions for the same. We have already seen such provisions in the Minimum Wages Act, wherein the minimum wages are fixed, minimum concept of minimum wages within the Code on Wages, wherein such minimum wages for such overtime work is being set by the authorities. Next is any commission which is being paid. For example, if there is any commission that has to be paid to the workers by the employers. For example, employer is giving some maybe 5% or 2% of the profits that the employer is receiving on any product. If the employee is marketing or is selling, or maybe any other case. For example, daily tasks are given, and for completion of such daily tasks or in addition to the daily task, if any worker is working, if any commission is being paid by the employer to employee, such commission will not be considered as a part of the wage. Next is any gratuity which is payable on the termination of employment, and any retrenchment compensation which is being paid at the time of the termination of a service. So any gratuity which has to be paid by the employer to the employee at the time of termination, or the retrenchment. We already know what is retrenchment. We have seen it in the Industrial Disputes Act. So if any retrenchment is being paid on termination of any employee by the employer, such retrenchment or gratuity which is payable at the time of the termination will not be considered as a part of the wages, and that is which is something which has to be paid by the employer, and he should not claim that this is a wage or which is a part of the wage. Other than this, in addition to the definition regarding the industrial awards or settlement, we have already seen. So in case if there is any industrial adjudication wherein a new wage structure is being created, then in that case, for such new wage structure which is being created by the industrial adjudication, it would be considered as a part of the wage, because the moment such adjudication has been made by any tribunal or the labor court, then in that case the previous old or the previous wage structure, old wage structure will no longer sustain or will remain alive. So then in that case the new wage structure which is being which has been adjudicated or which has been finalized by new adjudication, it would be considered as a part of a wage or a new wage structure. So that is the only thing which would be considered as a part of the wage. So with this we have seen two important definitions of the payment on the concept of payment of wages, and we shall see some of the provisions related to the payment on wages in the next session.